Without further ado, we will start our first panel discussion today. I would like to wish you all a very constructive webinar and a nice day or afternoon, depending on where you are. And I will hand now the platform to Professor Ayana Howard, who will be moderating the first panel on theoretical approaches. Professor Howard, the platform is yours.
Thank you. So for kind of the gamut of what's going on with the panels, so we have invited perspectives from both the France, EU, as well as the US perspective. And today is really about grounding the conversation. Given that there are different perspectives in terms of ethics, as well as legal, as well as laws, regulations, in order to start a dialogue, we all need to be on the same page. And so this first panel is looking and talking about both the ethical and legal perspectives, which, as we know, aren't necessarily the same. They do overlap, but they're also quite different. Even when you look at within the US, even when you look at France, and then when you cross-pollinate, it's even more different. So really it's about laying the groundwork. So just kind of the logistics, each of the panelists will give their remarks. You can queue up questions with respect to that, but we will hold the questions and the dialogue to the end. And so each one will present their perspectives. We'll hear from both the ethical and legal from the US side first, then the ethical and legal from the France EU perspective. And then we're gonna have a conversation. And one of the things about the dialogue, it is a conversation. And so if you have questions, if you think about things, if you just wanna probe and go deep, definitely queue up your questions and I will moderate that. But it is sharing information and sharing knowledge so we can move together pretty much in terms of thinking about this aspect of privacy, trust, and human oversight. So our first panelist is Paul Root-Lope. He is the Raymond Schnazi Distinguished Research Professor of Jewish Bioethics with the director of the Center for Ethics at Emory University. Paul, you have the stage.
Well, thanks very much. It's a great pleasure to be here. Before I start with my comments, I just wanted to thank all of the people who organized this. The organizing committee was really a wonderful experience to be part of. And I especially want to thank Anne-Elizabeth Courier, who really from the University of Nantes, who's visiting professor at the Center for Ethics and who was in many ways the driving force of this conference. So we only have 10 minutes to have this conversation, each of the speakers. So I'm only going to be able to give the broadest kind of outline. Artificial intelligence, as we all know, has permeated almost every sector of life, whether it's business, whether it's private life with our PDAs, our cell phones, when we make phone calls into not-for-profit organizations, when we call our pharmacists. In almost every aspect of life, artificial intelligence has begun to take over tasks that had been the domain of human beings. And in doing so have gotten more and more sophisticated, and some of the early problems of AI have been accommodated to some degree or another. So what has happened in the United States is there's very little, if any, real federal regulation about AI itself. We'll learn about that in the legal section. But what has happened instead is a great proliferation of ethical guidelines and principles being generated in the academy, in business, by not-for-profit organizations, by consulting groups. It seems like everybody has developed some kind of set of AI ethical principles. So for example, that in US government, the Department of Defense, as well as the intelligence community, there's a White House statement on artificial intelligence. So the government, for its own internal operations, has been trying very hard to figure out how to accommodate the challenges of AI. The major .coms and big organizations. Google has put out a set of principles. SAP has, Microsoft has, IBM has, all of the major organizations. I was at Google earlier this year talking to their AI ethics group. They have a whole group there that looks at AI ethics within the organization. Then in healthcare, there's an enormous attempt to try to figure out how we bring AI into healthcare. There are particular challenges in healthcare that I'll talk about in a moment. And so the many healthcare corporations and organizations have developed principles around AI. National professional societies, this happens to be insurance commissioners, but all across the spectrum of professional societies, whether they're academic professional societies or corporate professional societies, and in the legal profession as well. As we'll hear, there's a lot of concern about AI, not only outside the profession, that is applying legal principles to AI out in the world, but within law itself, and the possibility of AI reading contracts and doing other things within the legal profession. What all of these organizations have done is generate some set of principles or some set of areas of concern. They've created, this is just a sampling, though the one on the top left is European. They create all of these graphics that try to summarize the principles that they think are important for discussing AI. Here is Deloitte's, for example. Deloitte has generated this wheel with its 6 areas that it believes need some attention, that AI should be fair and impartial, robust and reliable. But one of the things that's important to understand about all of these kinds of principles is they tend to be aspirational rather than practical. They do often give some practical advice and talk about in the nuts and bolts of programming and in design, how we might integrate ethical issues into those designs. But at this point, they tend to be more declarations. We declare that AI should be fair and equitable and should be distributed in a just way. It should be someone should be accountable. Who? We still need to discuss. Who should be liable? We still need to discuss, but someone should be liable. In other words, they tend to be declarations of aspirational principle rather than really practical guidelines to how we actually do the work of implementing and designing AI. Now, those exist too. I'm not saying they don't. I'm simply saying if you look through the universe of these kinds of principles, they tend to be much more aspirational. And so what happens is they develop sort of an expert committee on AI, either in some governmental arm or in some corporation. They're charged with drafting a document for that organization. And what happens is you tend to draft a document that privileges your priorities and doesn't interfere too much with the handling of your business in such a way that you create aspirational ideas, but not disruptive ideas. So we'll look at, and in fact, many of them, by the way, explicitly talk about it being too early for regulation and things like that, so that they are clearly not advocating some kind of regulatory scheme for AI. They want to keep it more voluntary. So the US is a kind of pastiche of regulatory schemas. And when you look at them and try to summarize them, I argue that there are 6 categories, and I'm splitting these 6 categories into 2 kinds. One is applied, pragmatic, important issues that companies and programmers think about and need to think about. And the other are more speculative, futuristic concerns about where AI may take us. So the 6 categories, this is just my way of dividing them and thinking about them. First is what I call the internal issues. And this has to do with design, programming, how we design algorithms and how we put algorithms together into products. So first is reliability, the question of whether an AI product does what it says it's supposed to do and whether it does it reliably, and more subtly, whether the AI's understanding of what the goals are of that product are the same as ours, because as we all know, one of the challenges of AI is it makes no assumptions. So the assumptions we take for granted, AI may not take for granted. And there are many examples in the literature that people like me like to trot out to show really unexpected and sometimes very problematic decisions that AI products have come to because they didn't start with the same assumptions that we did. The classic example is if you ask AI how to cure cancer, and it says, sure, if you kill everyone who has cancer, there will be no more cancer. There was an example of a tic-tac-toe program where the AI program, all the AI programs should have played tic-tac-toe to a draw. One started beating all the other programs. It turned out it had learned how to turn off the other programs. And so they defaulted on a game, then it would turn it back on, and it would have won that game, then it would turn it off. So these are trivial examples and fun kind of examples that we like to trot out, but the subtler examples that can come up when you actually use AI for important tasks have to be worked out over time. So how reliable is it? We all know that AI is struggling and has struggled with the problem of bias, with the fact that AI learns by incorporating data, and the data that it gets is very often data that's been created over time by human beings, and therefore incorporates and reflects the biases that human beings have brought to that area. So the issue of bias against particular groups, whether they're racial groups in facial recognition, whether they're disenfranchised groups in mortgage programs, whether they're minorities in prison recidivist AI programs. There are many examples, many examples of how AI has reflected bias. And then finally, and there are others, and these are just examples, the transparency explainability problem. Outcomes alone are not enough in many fields to determine whether AI is effective. We need to know how it does what it does, especially in medicine. If it diagnoses disease, we need to know why it thinks we have cancer, not just that it thinks we have cancer. So that's an issue that's being explored in AI. Second, external issues, that is, once AI is working and it's implemented out in the world, how do we protect our privacy, which of course is a very important issue that this conference is dealing with. Not only our privacy in terms of it taking our data, but our privacy in the sense that once everyone depends on these programs, they will be making decisions and influencing our lives in ways that can violate some of our basic assumptions about how we live in the world and interact with services that are supposed to be for us. Shoshana Zuboff's book, The Age of Surveillance Capitalism, is a wonderful book that goes into great detail in the way in which we have become the commodities that AI uses to operate. And as that old saw goes, if you're not paying for a service, you are the product. Free services are trying to use our private data as a resource, and we give it away willingly, and then we become the fodder for AI's development. So how do we avoid being commodified by the very products that we're trying to create to serve us? And then finally, the issue of safety. How do we make sure that AI doesn't suggest or make decisions that can ultimately lead to harm, especially downstream harms that are hard to anticipate ahead of time, as well as the other kinds of collateral harms, such as discrimination and other things that we need to design in that first category of internal issues. The third is legal, and I won't say much about this because our colleagues will, but these issues of responsibility, accountability, and liability, who is ultimately responsible for harms that AI causes? How do we even determine what caused the harm in these complex chains of decisions that could include multiple AI programs at multiple levels? And is it the owner of the AI or the designer of AI? These are all issues that are going to have to be worked out by the legal profession over time. Then there's the impact of AI on society, social issues, issues, first of all, of justice and equity, and the distribution of AI, as well as fair access to data and benefits, the right to appeal AI decisions, and who gets to overrule AI in these kinds of situations. The impact of AI on job displacement. There have been predictions that 40 to 50% of jobs in industrialized and advanced societies will be replaceable by AI by 2030. Massive displacement of everything from drivers through automated vehicles to clerks through the ability of AI to handle retail sales, especially as everything moves online. And then finally, alienation from our labor, a discussion that's gone on for a couple of centuries, but may have a new implication when the individuals I deal with throughout my life are being replaced by dealing with algorithms. Now we begin to move into a little bit of the future, but there's still certainly, this is happening now, which is relational robot companions, sex bots, which is a big industry right now, and eventually robot rights. And then finally, the existential question of what's going to happen when AI surpasses us in intelligence, the abdication of human agency to artificial intelligence decision-making, and what happens when AI is finally able to understand and process things that are beyond human comprehension, and what happens with our own retrocession into a subordinate position vis-a-vis AI. So those are some of the main ethical issues that are being dealt with right now across the globe, but particularly in the United States, where law is not coming in and making those decisions. Ethical frameworks have become the leading edge of conversation about these issues. Thanks.
Thank you, Paul. Next, we have Matthew Scherer. He is an analyst associate with Littler Mendelsohn. Matthew, you have the floor.
All right, thank you, Dr. Howard. So one moment and I will attempt to share my screen. All right, so please somebody let me know if you can't hear my screen or if you have trouble hearing me. So my little presentation I've titled AI, What's the Rush? Are organizations getting ahead of both the law and technology in the adoption of AI? And just as background, so I'm an attorney at Littler Mendelsohn, which is one of the world's largest law firms of any kind, and in particular, the world's largest law firm that is devoted to labor and employment and workplace law. And my practice focuses on advising companies that use artificial intelligence in various workplace applications, including and especially companies that use it in the recruitment and hiring process. And I've noticed a trend that has grown increasingly frustrating, if I'm to be honest, and that is that companies often only come to me after the decision to use AI has already been made, and the decision was made with very little thought given to the legal implications or the ethical implications, for that matter, of its use. So when we were asked to write our presentations, we were given a series of questions to consider. And here I have highlighted from 3 of the 5 questions, I've highlighted some of the kind of overarching themes that I kind of drew from it, which would be, could you describe the main ethical and or legal challenges related to human oversight in health and well-being that ethics or the law does not currently or adequately address? And to answer the question, I would like you to think of a tree. And, you know, in particular, the metaphor that I'm using is that a tree has a root, it has branches, and it bears fruit. So let's talk about the roots of the tree. One of the roots in my head that has led us to this point is skepticism of the capabilities of human experts. This is a phenomenon that is by no means limited to the realm of the use of artificial intelligence. It's a general trend of anti-intellectualism and skepticism of the people who, whether through education or experience, are experts in their field. It has, in some cases, led to the rise of populist politicians, like the one who apparently lost re-election in the United States this past Tuesday. And it's apparent in lots of different spheres of life. Another one is a market climate defined by tech industry hype when it comes to artificial intelligence. So that is something that I think everybody who has kind of paid attention to both advertising on television and stories in the news media have probably picked up on over the past several years. There always seems to be this kind of breathless commentary whenever a new application of AI makes it to market and there's a wow factor of the latest ability of AI to do something new. And what ends up happening as a result of that is there has been kind of this self-sustaining cycle where there's rapid adoption of AI by organizations, and that leads to FOMO, fear of missing out. Companies don't want to miss out on the benefits of AI that their competitors might be reaping. And this kind of leads to this cycle where companies buy AI and they feel pressured to buy AI and to apply it wherever they can. And so that is the branches of this tree, this rush to adopt AI whenever and wherever possible. And the logic kind of seems to be, well, if it can beat the best Go players, surely it can do something much more mundane, like identifying the best applicants to be nurses, or deciding which neighborhoods to have police officers patrol at night, or determining which people convicted of crimes will commit future crimes. And above and beyond whether these uses are legal, there's obviously very serious ethical questions that these raise, because there are serious issues involving bias with AI that are difficult to resolve. So next part of this, I'd like to talk about the fruit. Well, sometimes the fruit of AI is wonderful, particularly in spheres where it augments rather than replaces human capabilities. We've seen many areas, from the use of AI in medical diagnosis, or in my field in the law, in order to help review documents and do other kind of routine and tedious legal tasks, to preparation of food, where there are ways that AI can be designed to either perform or help a human perform a task in a way that is far better than a human on their own would have been able to do so in the past. But sometimes the fruit is bruised, and it might be suitable for a stew or a salad where it's one ingredient mixed with various human capabilities, but you probably wouldn't want to eat it by itself. And sometimes it's rotten. Sometimes the fruit is just no good. Either the AI is ineffective or the AI is irreconcilably biased. And it's just not something where it is ready for use in whatever application you are looking at. And unfortunately, at least in the United States, my frustration has been that nobody seems to have much of a vested interest in helping organizations learn to recognize the difference between the different types of fruit that AI can bear. So as far as the remaining questions, there were two, and these revolve around the ethical and legal guidelines and principles that have arisen. And again, with the US focus for my responses here, the two questions were, are there current ethical guidelines and/or legal processes that can help to address these challenges? And which ethical concepts or principles are having the biggest impact on shaping AI-related regulations in your country or region? So the question of, I'll look at the first question first. And the answer is, there's none that matter, in the sense of significantly shaping US organizations' decisions on whether to adopt. Now, that's a slight overstatement. There are regulations that govern AI, and some of them do influence companies' behavior, but they are very narrow usually. And often they are regulations that weren't actually written with AI in mind. They were either written with earlier applications of earlier types of digital technology in mind, or they were written without regard to technology at all, and they're just kind of general regulations that govern how certain processes are supposed to work, and they have been kind of adapted or applied in the AI sphere. But by and large, these regulations, there's a lack of regulations that have real teeth in order to steer companies' behavior in the adoption and use of AI, except in a few very limited sectors such as finance. And for the second question, well, that kind of gives you the answer. What ethical principles or concepts are having the biggest impact on shaping AI-related regulations in your country or region? Well, what regulations is the answer to that? And my fear is that this is actually about to get a lot worse, or rather, we're about to lose the ability to make this much better, because it's entirely possible that the entire regulatory apparatus of the United States federal government could get struck down in the next 2 to 3 years. That's not an exaggeration. It has been a long-term project of conservative legal theorists and judges over the course of the past several decades that the administrative state of the United States is unconstitutional, and that the ability for government agencies to make policy and to issue rules and regulations is basically a usurpation of the role of the legislature, and that the administrative state therefore is just inherently inconsistent with the United States form of government. Now, that has for a long time been, frankly, something of a fringe position in the United States judiciary. But with the current composition of the Supreme Court, that's no longer the case. So the thing is, there is no shortage of organizations with national or international prestige that have issues or that are drafting ethical guidelines. But the proliferation of such voluntary guidelines and standards only serves to underscore the depth of the vacuum in hard law and government policy in the US. So in theory, to wrap up, regulations should make my job easier by giving companies an incentive to do the right thing and allowing me to point that out to them. Right now, I don't have many tools that are available in my toolkit, not that many arrows in my quiver that I can bring to bear to steer companies toward, forget even the use of ethical AI, but even to have helpful AI. I'll close with just one brief anecdote, and it focuses on the most common type of AI that I help companies use, and that is in the recruitment and hiring of employees. And in that space, we often get validation reports that purport to show how effective the AI is in helping to identify potentially good future employees in an organization. Now, for those of you who are familiar with statistics, for those of you who are or aren't for that matter, there's a statistic called R squared that is meant to basically show this is how much of something is explained by whatever model you have built. And, so if you have something that has an R squared value of 0.1, that means that 10% is explained by the model you're looking at. So, if you have a model that predicts, whether or not somebody is likely to vote for a particular candidate, and an R squared value of 0.1 means that they're about, whatever your model built gives you about 10% of the information you need in order to predict how that person will vote. I frequently see R squared values of 0.01 or less, or 0.02 or less on a good day, that companies are using in order to help recruit and hire people. To put another way, they are using technologies that are only 1 to 2% better than pulling people's names out of a hat and just deciding who to hire based on that. And the fact that we are using these technologies, or that a lot of companies are looking at using these technologies and don't realize how ineffective they are, and a combination of that and how biased they are, that's a point of frustration for me. And it's particularly a point of frustration that I don't have the legal tools available to me that I believe we should have in order to steer companies to make decisions that allow them to identify good AI and to have an incentive to make sure that when they use it, it is effective and not biased. And that will conclude my presentation. Thanks very much.
Thank you, Matthew. Next, we have two representatives from French EU perspective. The first will focus on the ethical perspective, and it's Cedric Villani, who is a mathematician, politician, and author of the report. And I'm going to mess it up, so I will apologize. Dans un sens intelligence artificielle. Cedric, you have the stage.
Thank you very much. Yes, donner un sens, to give a direction and a meaning to artificial intelligence. Indeed, that was indeed the report which I delivered to the French government in 2018. It's very instructive that I'm able to speak after the two representatives from the US in this seminar, and it's very interesting in that it will be able for me to stress on the contrast in some respects. First, let me recall a little bit about the story. The story of ethics and AI is at the intersection between two stories. The first is the story of AI, how it works, and we know it's a story that is a bit more than half a century long, and a story in which it had some advances, then setbacks. At sometimes there were a lot of turning points about what techniques you use in AI, and eventually the field over the past 20 years, say, turned from a very theoretical to very pragmatic state. And it was mainly of interest for logicians and experts of mathematics, to a state in which it's very pragmatic and in which it's very much developed by combination of developers and users, and in which examples and sets of data have come to play a crucial role. This means that currently in AI, in terms of ethics, the problems that were for quite some time thought to be the archetype of AI problem, like who is responsible when the AI takes a decision, whatever you call decision, or what happens, what is the problem when the car, the automated driving car goes into an accident, etc., etc. These issues currently are not the main issues for problems to solve, for ethical problems, and later for legal problems. These will be much more pragmatic problems about who has the responsibility in the development, how to test, etc., etc. The second story about the ethics is about ethics of data, and there's also a very long story coming back also from the Second World War, and in particular in Europe, coming from the very traumatic story about ethnical files and statistics, and triggered a very strong apparatus about controlling data, about forbidding some data, about putting a lot of control on this, and with institutions which are very strong in France and in Europe more generally about securing the privacy and about making sure what can be transmitted, what cannot be transmitted in terms of data. Now, when you go about with ethics of the AI, a lot of it will be about these issues, because AI is so much depending on data. It will be very much depending also about the ethics of data. And data is much less a technical problem as a trust problem. And this we can see in every instance where there is a program to develop, as currently in terms of COVID crisis. Whenever there are some choices to be made, be it at the national level or in companies, it will always be a problem of trust in transmitting data and so on. Now, once you have said that, one has to realize how much it also depends on the culture. The trust and the ability to share or not will have very strong influence on what you do with the data, and thus on ethical problems. And when it comes to the theoretical principles, I will concur with the two previous speakers by saying that all the many people and bodies and institutions around the world who worked on what should be the defining principles of AI are converging, have an extremely strong agreement about what should be done. And when it's, yes, as in the Deloitte referential that we saw, like responsible, safe, robust, privacy, fair, explainable, etc. Yes, everybody concurs. There are already some meta-analysis about the various prescriptions and recommendations, and there is extremely good agreement with not much difference from one culture to another culture when it comes to what we should do. On the other hand, when it comes to what we do in practice, things can be extremely different. And we see currently a strong contrast between the US situation, in which it's a lot about experiencing, going on with not much protection and a lot of experimentation, very daring, and the European situation in which, in contrast, there is a lot of development of caution, bodies to protect and councils, etc., etc. To the point that I can feel the trend in my positions, for instance, at the Scientific Parliamentary Office, where some of the associations, which are organizations concerned with ethics, say something like, okay, we know it's very important to regulate the use of data in medical applications, etc., but be careful. If you over-regulate, things won't be developed. And that is really one of the concerns that we are having currently. The possibility that the very strong development of bodies that protect and give advice and give warnings is something that will slow down, or in some cases even prevent the development of meaningful applications. Let's take one example in the fight against COVID. At some point, there was some hope that apps related to automatic tracing of people contaminated with the COVID might help for containing the pandemics. Currently, we can say that in the Western world, we haven't seen any important use of this. It does not have a significant effect. But there was last year really the question, like, how should we develop this? There's just a bit of AI in it, but it's mostly about collecting data. And there were all kinds of discussions and polemics about the way it should be constructed. And in France, there are a number of different bodies that gave their opinion, gave recommendations, gave safety guidelines, etc., etc. And we can see how much the process was suffering from this excess of being cautious. And all the problems that were feared, in fact, did not occur. We could see also that it did not have a much positive effect. So a lot of discussion about not much, but we could see how much the debate about should we do it or not do it, etc., was slowing things down. In that way, situation in America, on contrast, we can see that many experiments are being done without any control. And in some cases, it fuels catalogs of problematic situations. Actually, remember that the main book about problems, ethical problems related to AI algorithms is still the book of Cathy O'Neill, which was taking a lot of examples from American experiments to show how things could go wrong, like software that will predict if there is a possibility or not for a convict to commit crimes again if he or she is released, or should we use AI to help predicting where the police intervention should be needed, or should we use AI algorithms to help the training and evaluation of teachers, etc., etc. And all these examples, which were very well documented and analyzed by Cathy in this remarkable book, all these examples were resulting from experiments in the US, or most of these examples, in which there was no safety guidelines. And in Europe, these examples were not there, but the problem is the contrary, excess of cautious. Now, how to find the right balance to make sure that we can make the experiments and be enough daring, but with some safety belts, is really a main problem in front of us that we have to build, sometimes in the mid-ground between the Europe situation and the American situation, together with strong referentials such as GDPR, because we need this for the management of data protection and so on, with with ethical committees for sure, but avoiding the situation in which there are too many ethical committees saying the same thing in redundancy, but with some committees, building the trust at institutional level for sure, and with two main things that we will have to make sure that I will insist. The first is now we cannot make it general any longer. I mean, about the general abstract recommendations, it's okay. Now we understand them. Problem is to go now domain in each domain and see in this domain, these are the particular recommendations to make sure that the safety, there is the safety in the product, to make sure that the guidelines have been respected, to make sure that it's auditable, etc., etc. So specialize the discussion field by field. And the second thing we have to keep in mind is we have to have a body of control. Just like in when you have a repression of fraud in the, for instance, for food, we know that there are controls and we can examine what's in there, etc. We need to have experts able to examine what is in the product and how it has been constructed. I mean, the algorithm. Now, nobody is able from the source code or from the algorithm to see exactly what is done. And it depends on the database, which is impossible to read, etc. So this will depend on a combination of auditing the process by which it has been done, or testing the algorithm, like with some situations that are made up to reproduce and make sure that biases aren't there, or to detect when biases are there, etc. A little bit like you do when you do testing for a company to make sure that it does not discriminate on the basis of gender or ethnicity or whatever. And we'll have to develop this operational mechanism of control to go beyond just establishing rules. So in this way, I completely agree with the previous speakers that establishing rules and principles, now there is very good agreement around the world, but what are the principles to be sought after, but now we have to become tangible and operational in enforcing and making sure that they are there.
Thank you, Cedric. We will go on to our next speaker to talk about the legal perspective in France EU, which is our next speaker is Celia Zolinsky. She is professor of private law and director of the Master Law Creation and Digital from the Université Paris. Celia, you have the floor.
Thank you. I will share my slides. Okay, can you see the slides?
Yes.
Yes, thank you. So, good morning, everybody. Bonjour à tous. It's a great pleasure to be with you today to share our transatlantic vision on ethics and AI. And I'm going to present you briefly the EU and French approach regarding a legal perspective. So, sorry. So last year, the European Commission released a white paper on artificial intelligence. And in this document, the European Commission explains its wide-ranging plan to develop AI in the European Union. the EU Commission also released a European data strategy aiming to make more data sets available to businesses and governments to promote AI development. These documents explain the meaning promoting a vision that stems from European value and fundamental rights, and the conviction that the human being is and should remain at the center. The EU, therefore, puts privacy and other human rights at the forefront of its approach to AI. So it intends to go beyond its traditional market-based approach. The white paper specifies the pillars of the Commission AI strategy. Promote an ecosystem of excellence and establish an ecosystem of trust, which is a strategic goal in itself. To support what the Commission called the Trustworthy European AI, it initiated a twofold reflection: an ethical part and a regulatory part. First of all, the EU Commission considers ethics as a way to set up human-centric AI. The high-level expert group appointed by the EU Commission therefore published guidelines for a trustworthy AI. And here, 7 sets of criteria have been identified in this document: human monitoring, robustness and security, respect of privacy and data governance, transparency, diversity, non-discrimination and equity, social and environmental well-being, and accountability. And last July, the high-level expert group has also published an assessment list for trustworthy AI for self-assessment. And this questionnaire aims at enlightening stakeholders. It means that it encourages them to identify ethical tension during the development, the implementation, and the use of AI systems in order to make informed choices. From a legal perspective, the Commission has also attempted to identify the core elements of a future AI regulation in the EU. The aim here is once again to create a unique ecosystem of trust. This must therefore ensure the respect of EU law, especially regarding fundamental rights and consumers' rights. On one hand, the Commission points out that the legal approach must be applied to AI technology. This is the case for fundamental right legislation, such as data protection law, privacy and non-discrimination, consumer protection also, or product liability. However, the Commission also underlined the practical difficulty linked to their application, given the singularity of many AI technologies. Problems stem from opacity, complexity, or their partially autonomous conduct. The consequences may be disastrous, as you know, considering, for instance, liability arising from autonomous vehicles, or the difficulty which a victim of algorithmic discrimination may face to prove the existing bias. The Commission thus draws 2 consequences. First of all, the need to adapt existing laws, for example, regarding security and liability. Secondly, the need to create specific regulation. The Commission intent is clear: to avoid, as Cédric Villani said, AI over-regulation to support innovation. Indeed, Europe wishes to become a world leader in this area. The Commission hence choices to favor a proportionate approach and a sector-specific regulation. According to the same logic as the GDPR, in fact, the aim is for the respect of fundamental rights to become an asset, and this would favor virtuous actors on the market and ensure users' protection. The chosen method therefore relies, as in the GDPR, on risk assessment. The objective pursued is to apply the new regulation and conformity assessment regime only to the AI, high-risk AI application. Here, high risk is identified by two cumulative criteria: by sector, such as healthcare, transport, energy, or part of the public sector, and also by use in case of significant risk, in particular as regards security, consumers' rights, and fundamental rights. The EU Commission also considers high risks the use of AI application for certain purposes, such as those impacting workers' rights or affecting consumers' rights, and a special focus on facial recognition technology is made. The EU Commission recommends here a EU-wide debate given its tension with fundamental rights. And let's notice here that in France, the Data Protection Authority, the CNIL, addresses this issue in a very interesting white paper last year for this question of facial recognition. So for high-risk AI system, the Commission outlines general requirements which should become the cornerstone of a future regulation. And these new requirements related to training data or record keeping, information to be provided about the AI application, robustness and accuracy, and human oversight. For the other AI systems, the Commission promotes a flexible instrument of regulation based on ethics and responsibility, like a labeling chain that could guarantee that applications are based on secure and ethical AI and data. Following this white paper, the European Parliament has just published its proposals. A resolution from October the 20th proposed to adopt a regulation on ethical aspects of artificial intelligence, robotics, and related technologies. This regulation would constitute a common framework for member states. It should constitute a common base for the rule applicable to AI. Existing or future sector-specific legislation will be added. For example, we could discuss about content moderation for fake news and hate speech. The EU Parliament intends here to adopt an extensive approach to AI system. A flexible definition of AI is promoted in this document to avoid any early obsolescence of the regulation. It further applies to all techniques and their life cycle, and it also promotes a principle of extraterritoriality, since all techniques developed, implemented, and used within the EU will be concerned. Lastly, the EU Parliament adopts a based approach to recommend that the ethical principle be set out in a flexible way to accommodate the specificity of different AI systems. Firstly, the resolution advises to develop, implement, and use all of these techniques in strict accordance with EU law, fundamental rights, and data protection. And secondly, the resolution intends to promote several obligations regarding high-risk technology while proposing their definition. We can recognize here different principles identified by the high-level expert groups guidelines, as well as some mechanisms inspired by the logic promoted by the GDPR concerning personal data. This regulation method has been innovative since it combines ethical principles and duties. The EU Parliament thus intends to densify the normative strength of ethics, which is not legally binding. And this is both the advantage and the drawback of the different ethical charters aiming to regulate AI. To this end, it suggests to set out a risk and compliance assessment performed by the competent authorities. A European compliance certificate would be then issued. However, the ethical framework, once densified, shall certainly be extended by the creation of new legal rules. It will be then a matter of implementing some of these great principles, because the EU Parliament merely provides abstract guidelines which need further precision to be implemented. And this precision should ensure a trust environment also. These interventions could be of diverse nature because the promoted duties endorse very different values. Some are linked to fundamental rights, such as privacy or personal data protection, or non-bias and non-discrimination. And others are more vague, such as the social responsibility and gender equality principle or environmental sustainability. So let's mention two examples briefly. First, the right to redress. The respect of such a right raises several questions. For instance, that of the burden of proof of the damage or the question of the person liable. The legal framework here needs to be perfected in this regard. It is notably the aim of the announced revision of the directive on defective products and on another EU Parliament resolution of October promoting a regulation related to liability regime for the exploitation of AI systems. More generally, the proposal doesn't mention the risk of collective damage, which may be generated by AI beyond mere individuals. And this is a crucial point which should be addressed also. Bias and non-discrimination, there again, how to ensure the respect of this principle. One could regret that the Parliament does not go as far as advocating a non-discrimination risk assessment. This has been advised by the Villani report and also by the white paper published by the French CNIL and the Defender of Rights of France to prevent the individual and collective risks induced by algorithmic bias. There are the currently discussed proposal. The EU Commission is expected to put forward a legislative proposal by early 2021. The European legislative process is therefore only taking its first steps.
Thank you, thank you. So we will now have our Q&A for the next 20 or so minutes. We do currently have one question. So one question is, enjoyed your talk, thank you very much. If you think about the major challenges, if you were going to choose one, what would you think are the major challenges, whether it's in the US or in France, of addressing either ethical or legal issues surrounding AI? Does someone want to attempt to answer?
I'll just briefly say, to me, the most worrisome problem is that of bias. And the reason that is particularly concerning to me is that there seems to be quite a disconnect between what people's different definitions of fairness and bias are, and what sorts of steps in order to, you know, in the United States in particular, there's a tension between correcting historical injustices that people from members of disadvantaged groups have and American law's general preference for not making distinctions between people on the basis of certain characteristics. And what ends up kind of happening, at least in my practice, is that if there is an AI tool that has an adverse impact that that shows bias against members of certain groups, companies actually have a limited ability to correct for that, because correcting for it often means explicitly favoring one group over another, in the sense that whatever group is disadvantaged, well, if you make an adjustment that reduces that disadvantage, it may necessarily increase the disadvantage to other groups. It's so there's this kind of tension between, you know, if there's a biased AI, what can a company do about it under US law without violating the general principle that you shouldn't make adjustments or correct for, or basically you shouldn't make adjustments, or you shouldn't take steps that favor or disfavor a particular group. That might be a quirk that's particular to United States law, but that is kind of my biggest concern, is basically unwinding that issue.
Okay, maybe I'll add a few comments. Yes, bias is definitely one of the main and most urgent issues about AI currently. Also because we live in a world in which inequalities and injustice are very strong currently and are deepening, and there is very strong feeling, which is in so many democracies, about this problem of unfairness. Now, if the algorithms go on enhancing even further this unfairness, it will be very, very bad. Let's also notice that there's a lot of debate about already about the fairness in human processes, of course. And Matthew, you mentioned during your presentation that it was also a game of some politicians to say, okay, there is this which is unfair, and this, and to put doubt on the judgment of experts or people who are judging, etc. But we have to keep in mind that there are also some very strong studies about how unfairness can be rooted and unavoidable. I remember that very disturbing experiment in which I guess it was in Israel. There was a study about judges about judging on parole cases, and with randomized cases that they were having to judge on. And it was found that depending on the time of the day, judges were more lenient or more harsh, depending whether it was before lunch or after lunch. And after all, that's normal. We are human beings with our biology and our mood and so on and so forth. So humans can never be completely fair. It's normal, and it's okay as long as we recognize this and have mechanisms to limit the amount of unfairness. Now, the problem with AI is that when you have the algorithm giving you the thing, you might be tempted to think that it's something that is unbiased because it's a machine that says it. And in practice, it may reproduce the biases or even enhancing the biases that humans have. And that is an enormous problem for sure.
I want to add that there's a psychological element to this as well. So human beings are much more tolerant of other human beings' biases than they are of machine biases. So I did some work a few months ago with a national group of human resource people who were using potentially AI programs to help recruit, recruit people into their businesses. And one of them commented that if you get a group of people together to look through resumes and they're 80% accurate, which is probably they're not, it's usually much lower than that. But let's say they were 80% accurate and actually fulfilling the requirements of the position given what was in the resumes, people think that that's pretty good. But as one of them said, I can show that in some cases my AI program is up to 95% accurate, and all everyone wants to talk about is my 5% error rate, right? And it was the same thing with automated cars. We somehow think that the 40,000 accidents on American roads each year is tolerable, but one accident from an automated car shows that it's not an acceptable technology. So in addition to the bias, we also have to think about this particular kind of bias. The bias we have that we want our mechanisms to be much better than we are, and we have a much lower margin of tolerance of AI than we do of ourselves.
Yes, the example with the car is very good because it's clear now that to be acceptable, automating driving car will have to have a rate of accident that is not just lower, but much lower than the rate of human-based accidents. This was not necessarily clear to the early developers of the automated car, and they thought if we just improve things, it will be okay. Actually, they need to be much more than improve, just improve.
Right.
Yes, I would like to add another element. Regarding all the new interaction we have with the machine, with the algorithm, we clearly have to consider how to empower individuals, not only as individuals, but also as citizens, as a member of the society, to decide what we have to do to prevent, to guarantee our freedom of expression. And we have, as you may know, an important debate currently in France regarding facial recognition, but also with the regulation of hate speech and disinformation, or if you prefer, fake news. And the problem is the confidence, the trust we could have in the autonomous decisions regarding algorithm creation. And we have to consider this point and to address the question of how empower users or empower us as individuals and collective to decide what we want to do, what we want to consider as democratic debates, and not only trust algorithmic treatments. And this is very important, I think.
So here's another question. It was, thank you very much for those rich presentations. What is the American point of view on Celia's presentation on the future EU set of rules?
I'll actually turn that around to a question that I'd like to pose to Celia, which I'd actually like to know. So the resolution that was passed, I guess, just about 3 weeks ago now. What immediate force and effect does it have? And, kind of along the same lines, what additional steps have to be taken, whether by the European Commission or by, other arms of the, EU governance or of national governments? What else needs to be done in order to take that resolution and make it, actionable law? If that question makes sense to you.
So actually, currently we are discussing in the EU of this possible future legal framework, taking into account this ethical consideration, the question of liability, the question also of how to promote our industrial sector in regarding autonomous vehicles. So we have to address the very huge question of balance between protection and innovation, as we've done with the GDPR, in fact. So the EU Commission will publish its proposal regarding all this proposal of the EU Parliament in the spring of 2021. And we have a lot of debate in France to define not the good, but the position regarding this balance between innovation and protection. So there's different question for each sector. I'm especially examined the question of, as you understood, maybe the question of regulation of algorithm regarding hate speech and disinformation. And here we can address the question of transparency of algorithm, of explainability of algorithm, and in fact of sovereignty, individual and collective sovereignty. So there's a huge debate in France on all these topics. And if you consider facial recognition also, there's a huge debate because of the terrorist attacks of last day. We have new proposal to have facial recognition techniques deployed, for example, to secure our schools or our church. And also there's a very important tensions between all these questions. So I can't tell you what will happen exactly, but what I can tell you, if we have to have this debate, this democratic debate, and it's very important regarding, you know, with the COVID crisis, we have this proposal and this development of application to monitor the COVID the person victim of COVID. So we have a huge debate on this question also. So as you know, French love debates, but we need those debates, and it's very important today to have this debate with you also, because we have the main difficulties, the main consideration regarding what we want what society we want to build for the next generation, and we have maybe clearly to decide now the way we want to go.
And just to comment on that question, I think when the time comes that the US does start to really think about regulation, or if President Biden puts together a commission or something like that, the great work and the deep work that the EU has done already will be an important resource for the eventual US decisions about regulation, which will come sooner or later.
Let me concur in that so far the European political construction, let's say, has shown its strong abilities in defining norms, regulations, and so on. A very different approach than from the US. Actually, we need both, a good dose of experimentation and good frameworks. And currently in this area, Europe is working on the frameworks and the regulations. Let me also comment on the facial recognition debate, which is technically tricky and which eventually depends on what actions, what databases, etc. In the action of recognizing, I mean, you could as well have human people who are experts in recognizing, and we saw that some humans are able to identify people can be identify thousands of faces of people who are known as dangerous people, etc., etc. But these are humans, and the fact that these are humans on the one hand, algorithms on the other hand, with possibility to chain the recognition with some automatic action makes all the difference. As always, it's about the issue of whether it's an automatic mechanism or some human-based mechanism.
So if you think about some of this conversation, regulations was mentioned and things like that, facial recognition. One question is, how do you make the determination when you're thinking about risk between high risk and low risk AI applications? How rigorous should that assessment be? And will it be only for high risk applications such as facial recognition? Any thoughts?
Okay, it's difficult to give a general answer. It really depends on the field. I mean, it's definitely not just an algorithm that may be a high risk or low risk. It's algorithm in situation with a certain human chain, etc. And if you are using a given algorithm in I don't know, in a regular manufacturing process or in a financial process in which one mistake can make you lose 1 billion in 1 second, the evaluation of risk will be very different. So whatever, I would say, evaluation of risk is not, there's no general answer that can be given by the developer or the scientist. It will depend very much on the problem to which it is applied. And one has to keep in mind in general that one of the characteristics of AI with respect to other fields of science and technology is that it depends so much on the use case compared to other problems in which the scientist or the engineer has the control of what will occur.
Yeah, let me elaborate on that in one way, which is there's risk internal. So Cedric's point about some algorithm that's being used to help make financial decisions can make a decision because of a problem with or an issue with the algorithm that causes someone millions of dollars. But then there's also facial recognition, which may not be high risk at all if I use it in my store to see when a valued customer comes in so that I can send a clerk out to greet that person because I really want to take care of my valued customers, versus when it's being used on the street to try to identify people with outstanding warrants. So, there's the internal question of risk. How does the algorithm internally process things, and can it make bad mistakes that are problematic? And then there's the use of the algorithm, which is a completely separate question. Algorithms can be used or misused, or they can be used for things of low risk or high risk.
So we have time for one more question. So the one I'm going to choose is, I wonder about the panel's thoughts on who owns the data. Is it the individual, government, or the organization that collects it? How does that differ between EU and the US?
Okay, let me start to give a first try. First, recall design is politics. When you decide what's the infrastructure of your database and who has the decision on the data to put, etc., you are setting up a political chart about who has some power over the decision and who has not, and so on. And that may be a big thing, but it's a big thing. Again, it's very much an issue of relations in the human world. And by the way, when you set up a database for use, for applications, and so on, you usually have 3 types of problems to overcome. Some of the technical problems, like how to have fast access to normalized data, etc. Second issue is whether it's ethical and legal to process data in such and such way. And the third is the political problem. Who will have the right to put the data? How will the data be shared? Who will have the knowledge of the information that something has changed, etc.? And that third problem, in many cases of application of public interest, is the big one that you did not consider first and that would make everything stumble. I could see it in my political activities very clearly in the field of transport, for instance. And there are big issues, for instance, in my constituency about how to use AI to improve the transport by means of shared mobility, mobility on demand, etc., etc. And this issue, who should have the transport data, is a nightmare. Should it be the mayors? Should it be some company? Should it be the state? Should it be the region? Should it be a special conglomerate that you set up to make this? And if that is a special conglomerate, will it be public, will it be private? Who will control it politically? These are very tough questions that depend on which field you are considering. And I cannot say specifically in which way, but I'm pretty sure that practical solutions to this issue will be different from one side of the Atlantic to the other.
So in the United States, and I'll have to preface this that I am less an expert in data use and privacy laws than many other lawyers in this space in the U.S. But as a general rule in the United States, ownership of data once it's collected is a matter of contract, and contract law on this point in the United States is very friendly to the companies that collect the data right now. And as a general rule, in most cases and in most places in the United States, the company that collects data is the owner of it and gets to do whatever they wish with it. With some limitations about sharing information with third parties. But as a general rule, an individual does not own their own data once it is collected in the United States. And that is in and of itself a very, very significant point of debate and tension. But as of right now, there has not been a move anything like that in Europe with GDPR for at least a national level law that would give people more autonomy and ownership of their data after it's collected by a company. It's different when data is collected by a government in the United States, but when you're talking about data that is collected by a private sector entity, by and large, that entity owns the data once it's collected.
And of course, there's one other data issue that's become quite prominent, and that is the issue of sweeping the net for publicly available data that individuals consider to be private, even though they've released it out into the digital universe. There is a disconnect between people's activity online and people's feelings about privacy that sooner or later is going to have to be resolved in one way or another. You see over and over again these reports where some reporter goes to some, extremely capable hacker, and they look on the web and collect all the data about that reporter. And every single time, the reporter is absolutely shocked about how much of their personal data is out there in the world. And it happens over and over and over again. And the general public still hasn't wrapped their mind around the fact that we dump all of this personal data out into the digital world and then are shocked when bots can sweep through that digital world and find out all kinds of things about us that we didn't realize we were releasing.
Maybe if I can, that's why we need so much education programs regarding what we have to make with our data, what the other could make with our data. So education program have been launched in France regarding the young people at school, but we have also to develop education programs for firms, because a lot of maybe only French firms, I don't know, but they don't know what they can do with their data. So we have to develop the education of what we can, how is it interesting to share the data, for example, to promote competition between different partners, for example, and not only just keep our gold, because we are so stressed to share the data because it could be an asset which someone else could benefit and not us. So to be well educated, well informed of what we can do with our data is very, very important. And that's why the EU and France promote what we call the portability rights of data to inform ourselves which data have been collected and what we can do with our data with, for example, development of some other system like personal cloud computing, etc. To be informed and to be empowered regarding our data is very important also.
Yes, here we are going into the strong and important and tough subjects, as the examples of Celia show well. Some quick remarks to continue on this. First, there is the status of personal data, and in particular in the field of health, the doctrine in France, in Europe, is that such data are not owned by the person on which they are collected. They are not owned by the company either. It's some kind of public good, but whose use is subject to the consent of the person on which it has been collected. It's a little bit like an organ, you know, when there is an organ gift, a kidney or whatever, you cannot say that you cannot sell your kidney, but it's something part of the public good because it can be used to save a life, but of course there has to be the consent of the donor. Now, of course, it in practice can be very tricky, and some people say we should have reward for personal data and people should have ownership of their data, but I find this difficult to support, in particular because one set of data or the data of one individual is usually of no use. It's usually for companies to make some profit or for the society to make value. You need to put together a number of data to get some inference and so on. So it's the collection of them that gives really the value. Another comment is about the sharing of data. We are seeing a lot of difficulties in practice to foster the sharing of data between actors where it should be useful. And to some extent, it's normal. Companies have been hearing for many years, data means a lot of value, data is the new oil of the 21st century, etc. So they think, okay, why am I going to share this data if it's so important? I should keep it for myself. And that is a real problem we have to overcome. My third and last comment about this is there are two, you know, like monsters that people are in general afraid to give data to. This can be the state or government on one hand and big companies on the other hand. And how do you rank between those two risks or monsters that are feared is an issue. There was the subject with the apps against the COVID, and there really was a problem in discussions like in France or in Germany, like should we have this application managed by the state or should we have it managed by one of the big American companies like Google or Apple? And in particular in Germany, let's say the idea that state-controlled data is such a danger, which is coming from very deep from Second World War and so on, is so strong that the society and government would prefer to have the manager of the data that is a big foreign company rather than the state. So these are subjects and cases and dilemmas that will come back again and again, and that will be much more concrete cases where you have to make an arbitrage than issues about what is the decision of the AI and who is responsible, etc.
Thank you, Cedric. We're actually at our 10:30, a little bit over. So I want to thank the panelists for participating, having a dialogue, answering and asking questions among yourselves. For the attendees, we have a small break, so you can run off, please come back. And when we return, we will 10:45, no later. When we return, we will talk about regulations and also provide the industrial perspective on this aspects of ethical management of AI. Again, thank you, panelists, for participating at the first panel of the symposium. And we will see you in about 13 minutes.
Thank you for moderating it, Dr. Howard. Thank you.